Good morning. I'd like to call the Lyon County Board of County Commissioners to order. It's Monday, March 16th, 2026. It's 9:00 a.m. Board of County Commissioners meeting. All or some Board of Commissioner members may elect to call in to this meeting. The public can access this meeting at above address. Roll call. All commissioners are present. Pledge of Allegiance. Please stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all. This brings us to public participation. No action will be taken on any item until it is properly agendized. It is anticipated that public participation will be held at this time, though it may be returned to at any time during the agenda. Citizens wishing to speak during public participation are asked to state their name for the record and will be limited to 3 minutes. The board will conduct public comment after discussion of each agenda action item, but before the board takes any action. Do we have any public comment? Seeing none in the room and none online. For possible action, review and adoption of the agenda. Has everybody read it? And
Move to adopt the agenda.
let me go to public comment real quick. Is there any public comment? Seeing none, do I have a second? Second. We have a motion by Commissioner Hendricks, second by Commissioner Casanelli. Those in favor say aye.
Aye. Aye.
This brings us to item number 5A, workshop for discussion and possible action. A workshop of the Lyon County Board of Commissioners to review and discuss the current draft of the code enforcement ordinance. The workshop is intended to focus on draft code enforcement ordinance and is not for the review of active or abated code enforcement cases. And I think if maybe you can tell us why we're here, get us started. And
Yeah, absolutely. So today's workshop, we'll be on the next slide. So we're here to provide an overview of the other PowerPoint.
just so everybody knows that if you got a question that you need to ask him, go ahead and just speak into the microphone on the board. Don't look for recognition, but please state your name so that at least on the record, they know which commissioner is talking.
Mr. Chair, may I ask for a 5-minute recess to put the presentation on the flash drive?
Okay, we're going to take a 5-minute recess. We'll be back at 9:08. Okay, we'll bring the meeting back to order. Community Development Director Gavin Henderson.
Thank you, Mr. Chair. So today's workshop's purpose is first to explain why a new updated code enforcement ordinance is needed. We're going to walk through some key provisions of the draft. We're more than happy to go over section by section of the draft. As we got through the code enforcement update, we realized we had to rewrite that whole code section, and that's really why the workshop was requested by staff. There's a lot of information in it. We want to make sure that information is right and what the communities need, and that's really the reason why the workshop was requested. And then last step is we're going to gather questions, concerns, and suggestions from the board and participants in the workshop. Like I said, with the goal being to have this come forward to the board for future proposal and adoption in the best form possible. So why update Title VI, Chapter 1, which is the current nuisance ordinance in Lyon County? So first, the ordinance is intended to provide clear definitions on what constitutes a nuisance and a public nuisance. Right now, some of the language can be interpreted differently, which can make enforcement inconsistent. By clarifying these definitions, staff, property owners, and the public will have a better understanding of what conditions are considered violations. Second, the proposed introduces a structured fine system. The goal here is not simply to penalize people, but rather to create a consistent and predictable tool that helps encourage voluntary compliance. Having a defined schedule of fines ensures that violations are addressed fairly and uniformly. Third, the ordinance would formally establish a compliance abatement program. This is currently how we currently operate, but now we're putting pen to paper and codifying that. So this provides property owners an opportunity to correct violations within a reasonable time frame before more serious enforcement actions occur. The focus is always resolving the issue and bringing the property into voluntary compliance. And that's kind of the theme we wanted to carry forward in the ordinance update. Fourth, the update creates a defined process for collecting unpaid fines. If fines are issued and remain unpaid, the section outlines the legal mechanisms available to the county to recover those costs. And finally, the ordinance clearly outlines the full code enforcement process, starting from the initial complaint, through investigation, notice, compliance opportunities, and ultimately resolution if needed. The intent is to make the entire process more transparent, structured, understandable for both public and staff. And overall, these updates will help us collaboratively push forward a more complete code enforcement ordinance within Lyon County Code. So this is just some of the sections in the draft ordinance. I didn't put all of them in there, but just wanted to highlight a couple of them. So section 1 adds the formal title of the ordinance. Section 3 introduces clear definitions which help eliminate ambiguity when applying the code. Section 5 defines what constitutes a nuisance, while section 6 provides clear language related to unlawful living in an RV situations that may arise in code cases. Sections 8 and 9 outline the abatement procedures and how a public nuisance determination is made. And section 11 establishes a process for abating a public nuisance once that determination is made. Sections 12 through 15 lay out the notice, compliance, and recording procedures, ensuring property owners receive proper notice and documentation throughout the process. Sections 21 through 23 establish the fine structure and citation process. And finally, sections 25 through 28 outline the compliance abatement program and the process for requesting a hearing with staff. And now I'll leave it to the board. We can go through this section by section. There's 28 sections, or we can kind of go through whatever ones have a greater importance.
It's up to the board how you guys want to move forward.
Move forward and pick on the sections that we have.
One section at a time.
Well, I just.
Just wherever we have a problem,
Yeah,
just ask a
wherever we
question.
Perfect. So section 1, like I said, adds the formal title of the ordinance. So while this may seem like a small change, it's actually important for an organizational and legal clarity standpoint. By formally naming the ordinance, it allows the code to be clearly referenced in enforcement actions, legal documents, and future amendments. It also helps staff, property owners, and the public quickly identify the purpose of the ordinance when reviewing the municipal code. So in this slide, you can clearly see a lot of the red cross throughs is just a formality, kind of setting up the rest of the changes. We're not actually adjusting the language in this part of the existing code. We're more or less deleting it and adding new, if that makes sense. Section 2 is the purpose and scope. So this section states that the maintenance of property, buildings, and structures and premises must meet the standards established in Lyon County Code in order to protect the health, safety, and general welfare of the public. It also clarifies that violations of the nuisance ordinance are subject to penalties and fines as provided in Lyon County Code and Nevada state law. Additionally, this section recognizes that code enforcement is an important public service. It establishes that Lyon County must have a comprehensive enforcement system. It also clarifies that the procedures in this chapter do not replace other legal remedies, but instead operate alongside any civil or other enforcement actions that may be available under the law. Overall, this section establishes the legal foundation and intent of the entire nuisance ordinance. So again, in this slide, as we move forward, the new information for the code enforcement ordinance as it's currently drafted is going to be outlined in blue. So we can see the purpose and scope. This is section 2, and then A and the following information.
Yeah, on A1, I was reading through that. We have protect health, safety, and general welfare of the public. One word that I think would basically be a good one to throw in is health, environment, safety, and general welfare, because we do have a lot of places where people are dumping their oil. You can see it from the road. They're draining their oil, changing their oil. They roll cars over, all the fluids in a car, they're laying on the roof, where we do have a lot of vehicles that are laying out places in people's property. I know we can call Nevada environmental, but I think that it's something that our code enforcement should be able to say, this is a problem. It's in our code. We're calling environmental and having them come out and get it taken care of.
Absolutely. Now, will the inclusion of environmental, the state does have more teeth in those scenarios. Is that still the case as far as wanting to rely on the state, but keep this still a code enforcement issue?
I'm kind of looking at it as our enforcement officer should say, this is something I should be looking for. And if I find it, I'm going to make sure that it's part of my job to report it.
Okay.
I don't think we're going to run out there and do anything because Nevada environmental, NEPA is going to take care of it, but I think it's a requirement that we notice those things and ensure that our environment doesn't get polluted because of the runoff and penetration of the stuff into the ground.
Thank you. Section 3 is definitions. There was 16 definitions added to the code enforcement draft. Including these definitions is important because it provides a clear and consistent meaning for key terms used throughout the chapter. This helps ensure that the ordinance is interpreted the same way by staff, property owners, and the public. By clearly defining these terms related to nuisances, enforcement actions, and compliance procedures, it reduces ambiguity and helps avoid confusion and inconsistent enforcement. That's the goal of including these definitions. A lot of these are violations that we currently have issues with, and a definition would help clarify that at that initial interaction between the property owner and staff. We feel like we also added definitions for abandoned vehicles. We defined the nuisance side of things, Lyon County Code. If there's any definitions that are unclear at this time or that the board feels like need to be added, more than happy to make those changes as well. Any of the definitions that had an NRS backing, we included that at the end of the definition, just to further clarify that that is not a definition that staff just came up with, that is in state law.
So
When you're looking at abandoned vehicle, meaning any vehicle A and B, it has to hit both of those things. A and B, or is it just one of those two things?
It says or, so it is one.
Okay, so that's the one B is one I wanted you to talk to about when we get to the enforcement side.
Okay. Okay. Moving forward, we get to section 4, which is the conflict of ordinances. This is a pretty standard code inclusion. So this section just clarifies that if a conflict exists, the provision that provides a greater protection of public health and safety, if we also want to add environment into that, just to keep it consistent if we can. And then staff thought this language is important because it ensures that there's a clear direction for how the code should be applied when multiple regulations may overlap. Ultimately, this provision helps ensure that the county can always apply the standard that best protects the health, safety, and general welfare of the public. Is there any questions, or do we want to include environment in that definition as well, or into this part of the ordinance? Consistency.
Yeah.
Right. Moving forward, nuisances enumerated. So this section essentially defines the specific conditions that are considered nuisances under the ordinance. This section identifies several examples, including dangerous structures or conditions, buildings that remain in an unfinished construction for more than 180 days without a permit, and properties that contain debris, garbage, hazardous waste, or other conditions that create health or safety hazards. It also allows the enforcement official to determine that a condition may be a nuisance when it creates a health, safety, and fire hazard under applicable codes such as the International Fire Code, International Building Code, International Residential Code, or other Lyon County code provisions. Additionally, this section clarifies that certain violations under Nevada law and land use violations under Title 15 of Lyon County Code are declared to be nuisances. Overall, this section staff felt was important to add because it clearly outlines the types of conditions that may trigger enforcement, giving both, again, staff and the public a clear understanding of what constitutes a nuisance. Section 6. So section 6 clearly places unlawful living in an RV as a violation of the nuisance ordinance and Lyon County Code 15.335.04.c.6. That is in the temporary use section in Lyon County Code, and it clearly states that you cannot live in an RV on a property without a valid building permit for a primary residence. So instead of reinventing the wheel here, we just reference another part of code. Really, staff wanted language that promotes a high level of action and grants the county the authority to require immediate cessation of occupancy. These are violation in cases that can drag out, and we want to make sure that we have the language there to make sure that we have quick action abilities in these scenarios.
Is there a time limit on that? Like if somebody came in for a wedding or whatever, and they were going to stay in their RV out front of your house, that's
That is code is not that specific as far as that situation.
yeah. So they're not a time specific.
We would go back to, are you living in it? If you are, like we see utilities connected.
Oh, okay.
You know, we see the large propane tanks being plugged into camp trailers. The slides out for an extended period of time. Those are clear signs that someone is living in an RV. Section 7 establishes the general responsibility for preventing nuisances and the authority for enforcement actions. First, it makes clear that the property owners, occupants, or anyone in control of the property are responsible for ensuring that dangerous conditions, nuisance activities, or public nuisances are not allowed to exist on the property. Second, it authorizes code enforcement officials or their designees to issue administrative citations and fines in accordance with Lyon County Code. This section also clarifies that when a violation does not create an immediate or imminent danger, staff may first issue a notice of violation, giving the responsible party an opportunity to correct the issue before further enforcement actions are taken. Finally, it states that these provisions do not limit the county's authority from using other legal remedies available under state law, local law, or common law if necessary. And then staff wanted to establish who is responsible for maintaining the compliance, and gives the county, and this section would give the county authority and flexibility to enforce the ordinance properly.
So on that one, would the owner and the renter or squatter all be?
Enforcement actions are taken upon the property owner. Staff does go out and have conversations with those tenants because sometimes that is staff's best ability to get contact with the property owner. But any enforcement action is put on under the property owner.
We had trouble with that before in the past, to where the property owner lived out of state, didn't respond, didn't do anything, and someone was living there and just destroying the neighborhood. And it just went on forever. I think it still is. So is that still going to be the same way?
That's how, other jurisdictions, it's a pretty common practice that those fall within the responsibility of the property owner. As it is their responsibility to make sure that property is in a habitable condition and meets county code. I'm not sure if there's a state law that would allow us to pursue the tenant in that space.
If the tenant's causing the problem, why couldn't we go after the tenant? And the one that I'm thinking of is, I believe the aunt or mom had the property and the son lived there, so that he was a renter or grandson. So he was technically a renter and it was someone else, family member that owned the property.
Yeah, so Steve Rye, District Attorney, two things on that. We do on occasion go after the tenant or the person that occupies the property. We will continue to do that. The second issue is one of the primary additions in this ordinance is this administrative process, which ends up with a lien on the property. And in order to do that, we do need to notify the owner. So they will be involved in that process, definitely.
So
But that does not exclude the tenant from obligations as well.
okay, so we could still go after them. You just brought something up and I don't know if it's still on this, but since you're standing there, in the past, like when we went through the Great Recession, the banks ended up with the properties. And then, we could find the properties or whatever, but they would go like a year out or whatever before they could get someone in there. Are we handling that lien, the fine process to where, the person buying the house knows that there's a lien against?
There will be a recorded lien against the property.
Okay.
Moving forward to section 8, so section 8 outlines the procedures for abatement of a nuisance. If after inspection, the enforcement official determines that a violation exists. After inspection means we received the complaint and our code enforcement official has gone on site and deemed there to be a violation of county code. We will issue a notice of violation to the property owner record. This notice informs the owner of the nuisance condition and provides 30 days to correct the issue. If the condition is not corrected within the time frame, a second notice of violation may be issued, again, providing time for compliance and outlining the potential fines for the continued non-compliance. We realize that the draft ordinance was to get action, but our current practices and statistics show us that 57 days is an average window for us to achieve voluntary compliance. Currently, how we operate is a 2 notice violation system, so we wanted to keep that within the ordinance moving forward. And then moving forward, if the nuisance still remains unresolved, it does state that the Board of County Commissioners may authorize the county to abate the condition directly. When the county performs the abatement, the cost for labor and materials can be covered from the property owner. In some cases, those costs may be placed as a special assessment against the property, which can be collected in the same manner as property taxes. Overall, this section establishes a clear step-by-step process for notifying property owners, providing time for voluntary compliance, and outlining how the county can address unresolved nuisance conditions if necessary.
Now, I hate to be a wordsmith person, but
Absolutely.
reading through this, many of the statements like I'm looking at B1, the notice must provide that the date specified by which the owner. It's the notice must specify the date the owner must abate the condition. We throw in all these words, and even when you know what you're supposed to be thinking about, you're going, I don't know, what are they telling me to do it? Are they telling me to provide something? Or so
Absolutely.
anytime we rewrite these ordinances, we should just make them clear English and not go all around the issue.
Absolutely. On to section 9. So section 9 clarifies who can determine a public nuisance existence on property and establishes the authority of the individual relating to the public nuisance. This was in the existing ordinance. We wanted to keep it and just provide some clarification as far as the specific individuals who can declare a property to have a public nuisance. Section 10 is a judicial proceeding, not a bar to abatement. So this clarifies the county's ability to pursue multiple enforcement options at the same time. Specifically, it states that if the county initiates a judicial proceeding or court action, that action does not prevent the county from also moving forward with abatement of a public nuisance under this chapter. It also confirms that the county retains the right to recover the costs associated with abating a nuisance. In short, this section ensures that legal action does not limit the county's ability to resolve the nuisance and recover associated expenses, giving the county flexibility needed to effectively address violation. This was again already existing in the current nuisance ordinance, just kind of moved around in the sections. Section 11 is procedures for abatement of a public nuisance. Basically, it was not clear in current county code the exact process for the abatement of a public nuisance. So the most current one we went through with the board was 85 Hart. So basically, we took that process and we put it to code. That way, staff has a process to follow, the public knows the process, and again, trying to be as transparent as possible during the public nuisance process. So this one states that if the enforcement official determines that a public nuisance exists, the property owner will receive a certified notice explaining the violation and providing up to 30 days to correct the condition. The notice also explains the possible consequences if the issue is not resolved, including referral to the district attorney and the potential for the Board of County Commissioners to consider a resolution declaring the property a public nuisance. Property owners are also provided the opportunity to appear before the board and show cause as to why the nuisance should not be abated. If the issue remains unresolved, the board may determine that no nuisance exists, require the owner to abate the condition, or authorize the county to perform the abatement. Similar to other sections, if the county performs the abatement, costs and any outstanding fines may be recovered and recorded as a special assessment against the property. Again, overall, this section establishes the formal process for notice, hearings, board action, and cost recovery when addressing public nuisances. Yeah. Section 12 is notice of violation procedures. So section 12 establishes the procedures for issuing a notice of violation. When an enforcement official determines that a notice of violation of the code exists, they may issue a notice of to the property owner outlining the issue. The notice must include key information such as the property owner's information, the location of the violation, the specific code provisions being violated, and the administrative fine associated with the violation. It also provides a list of corrections needed to bring the property into compliance and a deadline for completing those corrections when applicable. Additionally, the notice informs the property owner of their right to request an administrative hearing within 10 business days if they wish to challenge the violation. That request is put in at the second notice of violation once the citations start to request administrative hearing. That's also touched on later in the ordinance draft. And then finally, this section explains that if a hearing is not requested within that time frame, the administrative penalty becomes final and the county may proceed with fines and potential cost recovery. Overall, this section ensures that the property owners receive clear notice, understand the violation, and are provided an opportunity to respond or correct the issue. Moving forward, section 13, service of notices, citations, or summons. This section outlines the procedures for services of notices, citations, or summons. It establishes how official notices must be delivered, which may include standard mail, certified mail with return receipt, or hand delivery. It also clarifies that if a notice sent by certified mail is returned unsigned, the service is still considered valid. Additionally, this section states that the failure of a property owner to receive a notice does not invalidate the enforcement process, as long as the county followed the required service procedures. This section ensures that there is clear and legally defensible process providing notices to property owners during the code enforcement actions.
And my question here would be, if we're gonna spend time and money on certified mail, but it doesn't matter if it's signed or not, why do we even do that? Why not just send them a letter? Send them the cheapest way if it doesn't matter whether they get it or not.
It is a tool to alleviate, it's more for the court process to alleviate, the scenario where that individual goes through that process and says they never got the notice. Or they didn't know they had a violation or any of those situations. So in that position, that's what we use certified mail for those cases, and it does help, the district attorney, correct me if I'm wrong, but help the court in that process and, basically eliminate that.
Okay.
We don't use it a lot, because it is expensive. But when we get to that point in the scenario, like the public nuisances process or a process where we know it's going to go to the court, those notices then start getting sent certified mail. And you're absolutely right, somebody could not sign it, and that's why we put in that provision that said if we return it and it's not signed, that is still considered a valid notice to the property. Right, section 14 is procedures for recording a notice of violation. So the purpose of this section is to ensure that any pending code enforcement issues are documented in the public record, particularly for situations where property may be sold or transferred while a violation still exists. If a violation remains unresolved after the compliance deadline, the county may record a notice of violation with Lyon County's Recorder's Office, which provides public notice that the property is subject to an enforcement action. Before recording the notice, the property owner will receive a notice of intent to record, giving them 10 business days to correct the violation or to request an administrative hearing to establish a compliance abatement plan for their property. Overall, this section helps ensure transparency in property records and encourages compliance by notifying future property owners of unresolved violations. Originally, we had this as a part of every code enforcement process. We did include the language where may, because we want to keep it as a tool. It does become an administrative burden if we're recording notices violations on every property, because then we have to record a notice of compliance on the back end. So if we do see scenarios or there's a public nuisance where we know that the property is going to change ownership, we can go in and then record that notice of violation of the property. So future property owners are aware of the situation that they're walking into. Section 15 is the notice of compliance. So I just touched on it a little bit. So once a property owner has corrected the violation, they may submit a request to community development for a notice of compliance. The enforcement official will then verify that the violations have been corrected, which may include a reinspection of the property. Before a notice of compliance can be issued, the county must confirm that all violations have been resolved, any permits have been finalized, and any administrative fines or fees have been paid. If the original notice of violation was recorded, the notice of compliance will also be recorded, which effectively cancels the previously recorded violation. This section provides a clear process for formally closing out code enforcement cases once compliance has been achieved. Section 16 is just a brief statement that allows the county manager or his authorized designee the authority to make reasonable and necessary administrative policies to carry out the provisions of this chapter. So in an effort to give staff and the county manager the authority to create those small policies that can further the code enforcement ordinance effectiveness out in the field for property owners and code enforcement staff. Section 17 is the authority to inspect. So this establishes the authority for enforcement officials to conduct inspections. This section allows enforcement staff to enter a property at a reasonable times to investigate potential violations and confirm compliance with the code. During inspections, staff may conduct investigations, take photographs, or collect other documentation necessary to evaluate the condition of the property. If entry is refused, the county may seek legal authorization through a court-issued warrant in order to complete the inspection. The section also clarifies that if additional code violations are observed during an inspection, enforcement officials may expand the scope of the inspection to address those issues as well. This section ensures that staff has the necessary authority to investigate and document potential code violations in order to carry out enforcement duties.
Now, I noticed we had a late backup on this, and I had the same question written on mine. I don't believe we can just go on somebody's property. We can observe outside the property, and if we see something, we can take action. But I think this is in the law enforcement or the district attorney's lap, because you do have some constitutional rights where you can't just have one of our government agencies wander onto your property and wander around and look for stuff. So I think that might be
It can be
an issue.
It can be further clarified, but that is. Our current process is we have to hand deliver the notice of violations sometimes. So there is a scenario we have to access the property. At that point, we don't investigating the property, we're there to deliver a notice. After the conversation with the property owner, if they do allow staff to go out and investigate the property, I'm more than happy to do so. In the cases where they say no, or the property is posted, we do go through the administrative warrant process.
I know, but your first sentence says an enforcement official is authorized to enter upon any property or premises to ascertain there is a compliance. And we can't just wander on to somebody's property without a search warrant. I mean, I think it's great if, we can see stuff.
Right.
But I don't think I want somebody wandering around going in my garage and hey, I think I looked in your house and you have an illegal stove, so I'm coming in. I don't believe we can do that. I don't know if District Attorney Rye has a comment on that first sentence. I'm not trying to make it tough on a enforcement officer, but I believe that we could get in trouble by just wandering on people's property and looking around, unless it's something we absolutely observe from the border of their property.
Absolutely, and we can work with the district attorney's office to further clarify that section meets state law.
I don't want to get us in trouble here. Okay.
Section 18 is the demolition of buildings. So this addresses well, actually, the enforcement official, if the enforcement official determines that a structure is unsafe under the applicable building or fire codes, they must consult with the building official before issuing a demolition notice. If demolition is required, the notice will require the building to be vacated within a specified time frame, not to exceed 60 days, and require the property owner to obtain the necessary permits and complete the demolition. This section also clarifies that individuals occupying a structure after it's been officially posted as hazardous are not eligible for relocation assistance, particularly if the hazardous condition or nuisance was caused by the occupants themselves. Finally, it establishes that violating or ignoring an official posted notice on a dangerous structure can result in a misdemeanor violation with penalties allowed under Nevada law. Overall, this section ensures that dangerous structures can be addressed in a timely manner while protecting public safety. Section 19 is a prohibition against issuance of county permits. So this establishes the ability for the county to withhold certain permits when a property has an active code violation. If a notice of violation has been issued, the county may temporarily withhold permits related to repairs, new construction, or alterations on that property until the situation is reviewed. This review may be conducted by the building official, the community development director, the county manager, or their authorized designee. Purpose of this section is to encourage compliance and prevent additional development activity from occurring while significant code violations remain unresolved. Again, the staff felt like this was a good tool to again achieve that voluntary compliance. As far as if you have a permit in the system and you have a current violation and of significance, we want to make sure that that violation is corrected before the property moves forward. Section 20 is the enforcement independent of other officials. So this clarifies the county's authority to enforce this chapter and other enforcement authorities within Lyon County Code. This means that code enforcement under this chapter does not replace or limit the authority of other county officials who may enforce different provisions of the code. Instead, it ensures that enforcement actions under this nuisance ordinance can occur alongside the applicable enforcement actions when necessary. This section reinforces multiple enforcement tools across the county code may be used when addressing violations. For instance, again, unlawful living in an RV, that's a code violation that the code enforcement official gets involved in. If there's other situations on the property that would necessitate the sheriff's office, this is a specific code section that says those can work in tandem together. Section 21 establishes the procedures for issuing administrative citations. If a violation remains uncorrected 30 days after the second notice of violation, so we're 60 days into working with the property, the enforcement official or their designee, we say or their designee because we've had preliminary conversations of either the code enforcement official or maybe getting the VIPs to go out and issue those citations. And that'll be part of the process to kind of get ironed out at the end. The citation formally initiates the assessment of administrative fines, which are payable directly to the county. The section also clarifies that the collection of those fines will follow procedures outlined later in code. This section creates the formal step where unresolved violations transition into the citation and fine process. Section 22 is the contents of an administrative citation. So this section outlines the required contents of the citation. The citation must clearly identify the property owner, the location of the violation, and the specific code provisions that have been violated. It must also describe what actions are required to correct the violation, provide a deadline for compliance, and explain the consequences if the violation is not corrected. The citation will also list the administrative fine and explain that each day the violation continues may be considered a separate violation. Finally, the section informs the property owner that they have the right to request an administrative hearing within 10 business days. And if a hearing is not requested, the citation and associated fines become final. Moving on to section 23. This outlines the fines for administrative citations when property owners fail to correct code violations. If a violation is not corrected, additional citations can be issued for the same issue and the fines increase over time to encourage compliance. The fine structure depends on the property zoning for rural residential, suburban residential, neighborhood residential, resource, non-irrigated agriculture or agriculture properties. The fine is $50 per day. These numbers came from the previous code enforcement workshop that we had. After a 30-day period following the second notice of violation, that is when the property receives the notice of citation. The fine continues to accrue daily until the property is brought into compliance and a notice of compliance is recorded or filed with community development. Once the total fines reach $5,000, the outstanding balance may be placed as a code enforcement lien against the property.
I have a question on that. Well, what happens if so we're going out there, we're inspecting, it's costing the county money, right? And then they sell the property right before they reach that. We don't recover that at all.
That's why the enforcement, well, actually sell the property. That's a good question.
Because there's a lien on, if we haven't put a lien on there, then we eat the cost of it as a county, right?
Essentially the fines and the cost of going to the property.
And to me, it should be, if they're accruing something, they should pay for it.
So we can make the fines specific.
Oh, maybe I can't do that.
Steve Rye, District Attorney. So the purpose of the program is nuisance abatement. And so, yeah, there are instances where you're going to find somebody, they sell the property, somebody comes in and they will have those same obligations, but they get a chance to clean it up as well. And I understand you want to try to recover the county cost, but that's not.
But someone buying the property, I want them to be notified that they're picking up that responsibility.
They're going to know these condition of these properties. They're generally going to know when they buy it. And yeah, if there's a disclosure issue between the owner and the buyer, they're going to have to sort through that. But the code enforcement process is going to continue. historically, Gavin or Joseph could speak to this, but when the property is sold, that's usually a good thing in code enforcement abatement. And so we don't want to discourage that necessarily. And so that's why it's not an automatic charge against that person that purchases the property.
And Mr. Rye, correct me if I'm wrong, but if county records a lien on that property, that lien remains on the property regardless of who, if the title changes on the property. So
Absolutely.
yeah,
Right.
so even if the negligent owner sold the property, the lien is still with the property until it's satisfied,
The
correct?
lien would be with the property until
Yeah.
it's satisfied, correct? And the instance I think Chairman Keller's talking about is where the lien has not yet recorded, but there may be
Right.
assessments against the property. And that's a little bit trickier situation, but given that the program is abatement, we would work with that new owner to try to abate that process, abate the nuisance.
Okay,
And rather than start with collecting fees from the new owner.
thanks for
That
that
makes
clarification.
And the biggest thing I would want is the new owner to be aware of what he's stepping into. I mean, he could visibly see it, but knowing that the county's already gone against that piece of property and they're going to continue to. So we'd have to, I don't know, the notification is what I'm more concerned about.
And we can discuss that a little bit to see if there's a way to have some information on that, but offhand, there would be nothing recorded at that point, as you pointed out.
Getting back to fines for commercial, multifamily, mixed use, public facilities or industrial properties, that fine is $150 per day. Once that property reaches $15,000, the outstanding balance may be placed as a code enforcement lien. Again, this approach ensures that fines are proportional to the type of property and the impact of the violation. Daily accruals encourages timely correction, and the lien mechanism protects the county's ability to recover unpaid fines. Section 24 is the code enforcement lien. So the county can record a lien in the official Lyon County records to collect administrative fees, fines, abatement costs, and other related costs. Before recording, the property owner is given a notice of intent, explaining that the lien will be recorded unless all amounts are paid. The lien lists the owner's name, parcel number, property address, legal description, and amounts due. Any costs associated with recording or removing the lien can also be charged to the property. Notification, so a copy of the recorded lien is sent to the property owner by certified mail or hand delivered to ensure they are fully informed. If the lien remains unpaid, the county may proceed to foreclosure following the same process as other non-tax liens. This action must start within 2 years of the recording, and all other lien holders must be properly notified. Cancellation, once the fines and fees are paid or otherwise satisfied, the enforcement official records a notice of completion within 10 business days, which officially cancels the lien. And why a lien is effective, so liens are tied directly to the property, legally enforceable, and allow the county to recover all costs efficiently. They give clear notice to the owners and provide priority in collection compared to special assessments, which are broader and slower to enforce. Section 25 is the compliance abatement program. So this is essentially how we currently treat properties with unique circumstances or a cleanup that is going to take longer than 60 days to comply with. So this establishes the compliance abatement program, or CAP, as it will be called, which provides a structured process for property owners to correct code violations. A compliance abatement plan may be initiated by the court enforcement official through an administrative hearing when, in their professional judgment, a meeting is warranted. Alternatively, a property owner may request a hearing in writing within 10 business days of receiving their first notice of citation. The CAP outlines a clear and enforceable course of action to bring a property into compliance. It includes a detailed description of the violations that need to be addressed, a corrective action plan specifying the exact steps needed to remedy each violation, a reasonable timeline for abatement based on the severity and complexity of the violations, periodic progress inspections or reports as determined by the code enforcement official, and a final compliance deadline by which all violations must be fully corrected. The property owner is expected to actively work towards abatement according to the cap. During this period, citations are tolled, meaning they are temporarily stopped accruing. However, if the property owner fails to follow the cap program, it'll be a signed document between the code enforcement official and the property owner, that those fines will start accruing again. However, abated by the final compliance deadline, administrative citations resume and continue to accrue daily until the property is fully in compliance. Is there any, I guess, questions on the CAP program? Again, it's currently what we do administratively, but now it's a formalized process that the public is now aware of as it's codified within Lyon County Code. We did initially have this a part of every code enforcement violation, which would require a hearing, but at the same time, that is a huge burden to put on staff, and we would be in meetings all week to set up these plans. So essentially, if you go through the CAP, your fines are told, you have 10 business days, so 2 weeks, to reach out to county staff to request a hearing to meet with the code enforcement official to set up that plan. Essentially, if you comply with the CAP plan, all the fines up to that date will be dropped. Essentially, that would give you 2 weeks of fines that someone could max out and then be dropped. Anything after that, they would not be able to fall within the CAP program, and those fines would still accrue daily. So again, trying to initiate that voluntary compliance with the property owner and in a timely manner, and we feel like this addresses that scenario. Section 26 is procedures to request an administrative hearing. Any property owner who has been served with a citation may request an administrative hearing within 10 business days from the date the notice of citation is served. The request must be submitted in writing. It must clearly state the grounds for requesting the hearing. It must be filed with the Lyon County Community Development Department no later than 10 business days. The hearing will be conducted with the code enforcement officer who will review the case, consider the property owner's arguments, and work to ensure compliance with the code. The section 26 provides property owners with a clear formal process to contest or discuss citations while maintaining a fair, structured process overseen by the code enforcement officer. I did, after reviewing this, think it may be a good idea that there would be an appeal process in there. So if there was a property owner that wanted to appeal the decision, they would have the ability to do that, and that would be brought forward to the board as well. And we can have that formal hearing. And then section 27, procedures for notification of administrative hearing. When either the property owner or the enforcement official will request a hearing, the hearing officer will schedule a specific day, time, and location for the hearing. The property owner must receive written or electronic notice of the hearing at least 5 business days before the scheduled date. This notice can be delivered in several ways: by electronic mail, standard mail, certified mail with return receipt requested, or hand delivery. This ensures that the property owner receives timely and clear notification of the hearings, giving them the opportunity to attend and present their case while maintaining a fair and transparent process. And then section 28, which is the last section, addresses what happens if a property owner fails to attend a scheduled administrative hearing. Any owner who has requested a hearing or whose actions are the subject of a hearing and fails to appear is considered to have waived their rights to the hearing. This also means they waive any objections to the notice or the administrative citation as long as the hearing was properly noticed. This section emphasizes the importance of attending scheduled hearings. Missing a hearing can result in the owner losing the opportunity to contest the citation or raise objections, making it critical to respond and participate in the process. And then the next slide is just an overview of how the current draft works. So you have complaint received through either online portal, mail, or hand delivered. Once that complaint has been validated in the field, the property receives the first notice of violation. That gives them 30 days to correct the issue. Property not abated within 30 days, you receive a second notice of violation, which provides another 30 days to correct violation from the property. So property not abated within those 30 days, which again is a total of 60 days. Then you start the citation process. You have 10 business days to reach out to staff to schedule your hearing. And once those fines reach the maximum thresholds, we record the names and essentially start the process over with the notice of violation, which would give property owners again the opportunity to kind of take advantage of the hearing process and develop a compliance abatement plan for the property. And then the last slide is just the cited NRSs. Most of these are in the definition sections.
Commissioner Jacobson.
Thank you. A couple things, first. Staff safety and. Maybe just unsure of what may be happening. Are drones ever allowed to kind of? Look into the property, even if it's, and I'm not saying above their airspace, but off to the side just to make sure it's safe. Is that something we should consider, or is that not legally allowed?
Steve Rye, District Attorney. At this point, my recommendation would be that code enforcement does not consider that. If we need to use drones, that would be a law enforcement issue and we would defer to the sheriff's office. They have the program set up and they know the proper procedures.
And I thought that was the case. My next one, do we get reports, complaints, regarding neighbor disputes that may be unfounded? And do they, if they're persistent, do we have anything in here that protects homeowners from being falsely reported on?
Not specifically. We don't have anything within the current draft. We do run into that issue a lot. I don't know if it has any anecdotal evidence, but yeah, it is an issue. It is part of the validation process as far as going out there and validating the complaints. If it is deemed to be a neighbor to neighbor dispute, we don't get involved in that process.
What if they keep making reports? Do we have to follow up on that? And
Currently, yes, we do follow up on those reports.
so do we need to consider some teeth against false reporting?
We absolutely could.
That same thing that you're bringing up is what I wanted to go back to on 2B, where I asked about the or, and 2B on 60103. And it abandoned vehicle means any vehicle which has not been moved or used for more than 7 consecutive days reasonably appears to have been deserted. I could see people calling back and forth. I mean, your car could look deserted in probably about 10 minutes when the wind blows.
Sure.
Around here. And also depending on the time of the year. So like I own 2 trucks and a car. That car is not going to move in the winter months. So it's going to be parked. I'll be driving the trucks. So it might look like it's abandoned. So I just didn't like how that statement was.
Okay.
Maybe clarify a little bit more, registered vehicle, something. Because I could see exactly what Commissioner Jacobson's thing is. If I didn't like my neighbor, you're getting that phone call constantly.
Thank you.
Any more, Commissioner Jacobson? Commissioner Hendricks?
I'd like to know, does our code enforcement officer have any comments he'd like to make?
Thank you. Joseph Sanchez, code enforcement officer. Regarding neighbor to neighbor disputes that I do often get dragged into. I just recently attended the workshop for the city of Fernley code enforcement draft that they are presenting. One thing that they brought forward that may be views here is they are potentially going to institute a reinspection fee that would apply in those situations with a monetary value, you know, that would be assessed in those situations. So maybe worth considering.
Else? Commissioner Casanelli?
Yeah, I'd just like to, where can we find the list of actual code violations? Like for
So it's general, it's in nuisances enumerated section.
Okay. Is that like section 6 something?
60105, section 5.
That includes like violations on number of animals on a property and that's
Right,
all
yeah, that was wrapped in that general
detailed in that.
violation of county code, yeah.
overall. Okay. Thank you.
That's correct.
So I have one more thing, and maybe it's in here and I just can't find it. But I like that last slide that you had showed the process, and not the second to last slide, but we give a lot of time. A lot of time happens. It's 30 days, and there's an appeals process. So as long as you're working on something, it can last for a longer time. But where is it in here that do we have any teeth against habitual offenders that clean it up after
So we would roll
60
that,
days?
we would roll out no public nuisance, and then that would come forward to the board and be that formal process to handle those situations.
But is there something in there that says that you're gonna get, so you cleaned it up in 60 days? Nothing happened to you. Next week, I start all over again and do the same thing that I was in trouble for 60 days. And we're sending people out there. We're filing complaints and nothing's happening. And it's a proven track record. What I'm saying is the people that abuse this system is is there any teeth for those people? Not the people that, need help or there's a process, but there's some people that, and I could probably say 3 or 4 that I know of, that they're just gonna fight you every chance they get.
Sure,
So I thought maybe it should be in here for habitual
maybe we can label it like a chronic nuisance.
over a period of time. I think, so many offenses in a year, or over a 5-year process. I don't know what the time thing would be, but seems like people can clean up their act for one weekend and then screw it up for 60 days.
Sure.
And I've seen it. So.
Yeah, and I mean, just like any code, right? There's going to find ways to abuse it. The 60-day was just, that's usually how long it takes us to get voluntary compliance out in the field. So we thought it would keep that process the same. If there's a desire to shorten that process, so.
I don't know about shortening the process, but if they keep doing it.
Yeah.
Right. So they did it and then they cleaned up and then they did it again.
So would the
Okay.
intent be for chronic or habitual nuisances to shorten the process?
That could happen.
Okay.
There could be a penalty that you can't just keep doing it. Because otherwise you guys are just going out to the same property over and over. And there's not a whole lot of people that do that, but there's certainly a couple.
Well, and those are the biggest issues for us too.
Yeah. So without any more questions here, is there any public comment?
Mark, Jones, I just had a couple questions. Abandoned vehicles, what is the definition of a vehicle? Because if you go out to farmland, everybody keeps their old equipment to take parts and everything else out of it. So is that a vehicle? And I can guarantee you they're not registered because they're not in use anymore. So do we have some exceptions to different areas and, like that? Because I mean, some of these farms look like they're actually a used car lot. They've got enough stuff that they keep to work on. So I think that's something we need to clarify. The RV thing is kind of concerning to me because we have RV businesses out here now that are supposed to be kind of for traveling through and, and they become a living facility. They have the big tanks hooked up to them in the RV parks, but they got no place else to live. So, if I buy a piece of land, I want to build something, and I want to come out just on the weekends to work on my land. Is that a violation? Me living in my RV? And I just see some, that needs to be a little bit more clean. Because there's a lot of exceptions to what we're using those RVs for, especially nowadays, people can't afford to live. So I'd hate it. And then the last thing is the complaints used to have to be filed by somebody before enforcement got involved. Now enforcement can just go out there and see it themselves and get involved. That's kind of the question I have too. Because, you don't need to get neighbor against neighbor because that stirs up the pots. And before somebody had to complain in order to make it happen. So I just wanted to make sure that court enforcement have the authority to actually go out there and make a report. That's what his job is. So,
Do we have any other public comment?
For the record, Robin Biggs. I see the commissioners have hard copies. You have hard copies of the presentation? When did you receive those?
Or when you look on the agenda, you could pull it up and it's in the backup.
To clarify, the board doesn't have copies of the presentation, it's of the
No, we
ordinance.
have a copy of what was in the backup.
In the backup?
Yeah.
The agenda included the actual code listing. The presentation that was on the screen is late backup, so it was not included with that agenda.
It's, well, open meeting law says it's supposed to be available if it's to the public. Hard copies are available to the public when the commissioners get theirs. What was shown on the screen?
That will be included in late backup and added to the agenda available online.
So what is it that you have? Do you have the pictures that were showing up there? Can I see what your hard copy looks like? Or what you were looking at?
The hard copies are what's available in the agenda that's on the table. The presentation that was on the screen is not included as a hard copy yet because it was late backup.
So you had your opportunity. It's out there on the desk of what we have.
Can I see what?
It,
The
It's
hard
out
copy
there.
that they have is in the agenda.
It's the same as out there. If you want to see mine, go ahead.
That's fine. Is this for, did I hear that it's also for city limits?
no, we're county.
Wasn't it, went, okay,
Chairman Kelly, did we open this up to question and answers or are we doing public?
I'm sorry for doing that.
I'm just wondering what we're on that.
what did Mr. Hockaday say?
I asked if we'd open the board up to questions and answers, or if we were just having comments or public participation.
This is just public comment, so we don't respond to public comment. That doesn't mean staff can't clarify later when they get back up. I see Gary has his hand up.
Hello, can you hear us?
Yes.
Hello? Okay,
My question, I'm Diane Hansel, Stagecoach resident, and it's not really a question, it's a statement. We have people who move in first time into the neighborhood, and this has happened a number of times, and they immediately assume for some reason they can set up an RV and have a person living in it almost immediately as new community members. And I'm wondering if when people purchase a home in Lyon County, are they given by the realtor the zoning laws? Because they automatically assume it's okay to live in an RV in a residential neighborhood. So I think we could do a better job there, perhaps. And also these revisions, how long will they take to get them into place and they finally go into action? All right, thank you.
I struggled to hear what she said.
So did I, and was that under Gary? Okay. Any other public comment in the
Oh,
room?
shoot. Yeah, can you hear me again?
Yes,
Okay, let me get closer to the microphone. My statement was this. We live in a residential neighborhood, and when a home is sold in our neighborhood, it's happened a number of times. The new owners immediately set up an RV in their space. We have 2-acre plots, and someone begins to live in the RV. So I'm wondering if there is, with the realtors who sell the homes, do the new owners get the Lyon County zoning laws? Because they just automatically assume setting up shop, someone else living on their property is acceptable in this county.
I'm with Diane. My name's Gary Hansel. I mean, basically, just as an observer, it appears that people who move in, at least into our neighborhood, look around, see, 30 vehicles on a property, somebody living in an RV, and trash everywhere, and within weeks assume, well, that's how this goes, and they begin to do it, and there we go, we're off to the races. So I think Diane is maybe, in other words, is trying to ask or say, when a home is sold to a new, a new occupant, are there any codes or Lyon County regulations that are given to the new owners so that they don't assume that it's just okay to do that the week they move in, because that's what seems to happen, at least in our neighborhood. Thank you.
thank you.
Can we clarify both of their names for the record, please?
Diane and Gary Hansel.
Thank you. I'm going to close public comment if there's no more public comment. Okay. Bring back to the board, I think,
Stephen Ryan, I just wanted to clarify a few things I heard today that we'll incorporate into the draft ordinance. And if you have more before we recess, but first on the search of the property, section 17, we'll revise that. Never the intention that the code enforcement would enter the property without permission of the owner or occupant. So we'll add that language. We will investigate whether we can record the notice of violation to put future buyers or renters or anybody else on notice that there is maybe a pending code enforcement violation. False reports by neighbors and other false reports, we'll review that, add some language on that, and possibly look at the complaint form, because there should be a provision in there that advises against filing false reports to try to minimize those. Abandoned vehicles, we'll revisit that definition. Just for the board's clarification, that is the definition out of the NRS, I believe, but we'll double check that and make sure that it's clear so people know what is an abandoned vehicle. And then repeat offenders, we will review that. That's a good point, that they do need to be handled differently. And so I noticed in some of the other neighboring codes, there are provisions for repeat offenders. So I'll get with Mr. Henderson on that and Officer Sanchez to see if we can add in some teeth for repeat offenders. Was there anything else specific that the board mentioned?
nope,
Thank you.
it looks like it. So would this also require a motion to basically what he said? Or we just leave it alone and you guys bring it back?
It is for possible action, so if we wanted to maintain the record as far as those being the changes the board wants, to make a motion, staff understands the direction, so.
So do I have a motion?
Move to approve the draft ordinance, and okay, I'll just wait.
I think it's got to come back.
Yeah.
Directions.
Andrew Haskell, Lyon County Manager. So I don't think we can approve the draft ordinance, but what you can do is direct staff to come back with changes and
Okay,
bring it back to the board for further consideration.
okay, then I move to direct staff to make revisions as stated by the district attorney and bring it back to the board.
Second.
We have a motion by Commissioner Hendrick, second by Commissioner Hockaday. Those in favor say aye.
Aye.
Motion passes unanimously. Five B for discussion and 5-minute break. Bring the board back to order from number 5B. For discussion and possible action, a workshop of the Lyon County Board of Commissioners to receive a presentation and discuss the existing Lyon County building permit application, review and issuance process, and to consider potential board level policy direction intended to improve efficiency and support county staff and the building community in the permitting process. This workshop is intended to focus on building department procedures and is not for the review of individual permit applications. Department Director Gavin Henderson.
Thank you, Mr. Chair. So today's workshop's purpose is to provide an overview of the current building department process, discuss how applications are submitted, reviewed, and approved, gather feedback from the board of county commissioners and the building community, and discuss potential policy direction to improve building efficiency.
Yeah, Kelly, and I asked this to be placed on the agenda. I want to support, obviously, our planning department, look for ways in which our board policies make sense and are streamlined to be efficient and not create redundant work. Also, I'd like to listen to possible solutions which may necessitate budget concerns or additions as we head into the next budget cycle, such as program software or whatever that would help. So any of that information would be great for me to hear. Thank you.
And I think we might even expand a little bit on some of the builders, people in the industry that might have a little bit more to say, because it is a workshop. So.
Right. So we'll roll right into it. But before we actually dive into it, I did want to just emphasize that the building department exists as a public service. And staff's work is built on communication with the general public and the contractors. We encourage contractors and members of the general public to reach out to staff directly with questions, concerns, and feedback about their applications and the process. While staff does hear from some applicants, we want to ensure we gather all feedback possible and want to ensure everyone has the opportunity to be heard. Our goal is to listen and work collaboratively to make the permitting and inspection process as clear and efficient as beneficial as possible for everyone. With that in mind, let's review the core responsibilities of the building department. Our primary role is to administer and enforce building and safety codes. This ensures that all construction in the county meets the standards necessary to protect health, safety, and property. We review construction plans to make sure they comply with the adopted codes, and we issue permits for residential, commercial, and other construction projects. During construction, our staff conduct inspections at key stages to verify the work is being completed safely and correctly. The codes we typically enforce include nationally recognized standards such as the International Building Code, the International Residential Code, the International Energy Conservation Code, the Uniform Plumbing and Mechanical Code, National Electric Code, and local and county ordinances.
Go ahead, Commissioner Jacobson.
Thank you. So the fire codes,
right.
That is not part of Lyon County and what we do. So I think people need to hear that as well, that
we do not review plans for fire code compliance.
thank you.
So an overview of the permit process. So it starts when an application is submitted, followed by a review to ensure all required information is complete. The plans are then evaluated by the building department and any partner agencies to ensure compliance with the codes and regulations. If corrections are needed, they're communicated to the applicant. Once everything is in order, the permit is approved and issued. During construction, inspections take place. to ensure work is safe and compliant, and at the end, a final inspection is completed to issue a certificate of occupancy or completion. And we'll dive into each of these steps moving forward. Permit application submission. So applicants can submit their permits through our online permitting portal or in person at the community development office. Required documents typically include a completed permit application, construction plans, site plans, and any necessary engineering reports and the applicable fees. For projects that require fire district approval, the fire approved plans must be submitted with the application. Once submitted, staff conduct an initial review. This includes verifying that all required documents are included, confirming the project scope, assigning a permit number, and requesting payment of the plan check and administrative fees. From here, the process moves into the plan review stage where submitted plans are examined in detail to ensure compliance with the applicable code. The plan review process. So at a high level, this step ensures that submitted plans comply with all applicable codes and county requirements. Staff confirm the relevant codes and design criteria based on the project's location, type of construction, and occupancy classification. They review the construction documents to check for consistency and coordination across all plans, specifications and calculations. The review also involves coordinating with other departments and agencies such as planning, roads, utilities, and fire to obtain all necessary approvals before a permit can be issued. Staff verify that permit fees are correctly assessed based on the project's scope and value, and ultimately approve or deny the permit depending on compliance. Finally, once approved, the plans are properly stamped, recorded, and distributed for inspections and future reference. Next, I wanted to clarify a question we hear frequently. Why do plans examiners review engineered plans even though the engineer is ultimately responsible for the design? The short answer is that plans examiners review these documents to verify that the design complies with the applicable codes, regulations, local requirements, and accepted engineering standards. This helps ensures the proposed construction is safe, coordinated, and capable of performing as intended before work begins. Often, local amendments or jurisdictional specific requirements are overlooked, with designers assuming that the international code applies without modification. The plan review process helps catch these issues early. For large projects involving multiple firms, structural, civil, architectural coordination gaps or delays can result in conflicts or inconsistencies. Even when one firm handles all components, discrepancies between structural calculations and drawings are common. Plan review identifies and resolves these issues before construction starts. Finally, this review is not optional. Sections 106 of the IRC and section 107 of the IBC require that all construction documents be reviewed and evaluated.
So I got a question for you on that. It says even though the engineer is ultimately responsible, but isn't it the contractor that's ultimately responsible?
Depends on where the issue lies. Is it a design issue or is it a construction issue?
But they're gonna go after the contractor.
Yeah,
So
yeah,
he's responsible.
depends on the scenario. Next is permit issuance. So once the plans have been approved, the next steps focus on moving the project toward construction. The applicant pays any remaining permit fees, and the building department prepares the permit documentation. Approved plans are stamped and recorded, and then the permit is officially issued to the applicant. From there, construction may begin with inspections required at specific milestones to ensure the work continues to meet county code and safety standards. Next is the inspection process. Inspections are performed at key stages, including footings and foundation, framing, electrical, mechanical, and plumbing systems, installation, and finally a comprehensive final inspection. Inspection requests can be scheduled through our online system or directly through the office. All inspections are conducted by certified building inspectors to ensure compliance with the code standards. To accommodate timely scheduling, staff generally performs inspections next day if requests are submitted by 4 p.m. the previous day. This process helps keep projects moving efficiently while maintaining safety and quality standards. Next, I wanted to touch on typical factors contributing to delays in the process. First, applicant-related factors. So delays can occur when applications are incomplete at the intake stage, or when responses to correction requests are incomplete or submitted late, such as missing documentation or clarification. Supporting documents like engineering reports or site-specific studies submitted after the initial application can also slow the process. Changes to the project scope or after submittal may require additional review or fee recalculation, and scheduling conflicts or delays in payment of plan check or permit fees can add further time. Second, plan review and internal coordination. So the building department did receive a heavy influx of plans between October and December of 2025 due to the code update. This did create longer than average review queue. Staff has since caught up On the backlog, our oldest permit currently in the system is February 20th, so we're a little less than a month right now currently. Complexity, multidisciplinary coordination, and interdepartmental reviews, including planning, roads, utilities, fire, and environmental health, can also extend review times. Interdisciplinary conflicts or questions about code interpretation for unique designs may add additional time. Finally, regulatory and external factors. Changes in code or local amendments may require extra review. One of the most common regulatory factors we deal with is the special flood hazard areas, which comes with FEMA and local floodplain requirements. While we provide a lot of the education up front and guidance as applications apply for permits, this step is frequently missed or overlooked by applicants, and it can significantly impact timelines. Third-party approvals from fire district, utilities, or state agencies as well, as environmental or site-specific conditions like wetlands, grading, or flood zones can also add extended review times. Next, the goal of the workshop was board policy considerations. So we did provide a couple of ideas for the board. One option is establishing an MOU or memorandum of understanding with the fire protection districts to clarify and formalize the plan review process. The goal will be to allow fire plan approvals to occur concurrently with other reviews. This was a policy decision in the past. Nothing that we've changed since myself or Mr. Ray Brown have come to the county. But it has changed back and forth. And in order to prevent that from happening in the future, we feel like an MOU would allow the board to approve that, as well as the fire district boards. And then it's a clear, concise process moving forward. And any future amendments would have to come back to the board. So it is a transparent process if those changes are needed. Another idea is to engage third-party reviewers for larger commercial and industrial projects by defining applicability based on project size, valuation, risk category, and occupancy. This approach could prevent these complex projects from creating bottlenecks in the overall review queue. Any contract for services would have to come to the board for approval. Currently, third-party reviews typically charge a fee equal to about 65% of the building fee. And then third, for consideration is to create a feedback system that allows contractors and the general public to submit constructive input, including a customer rating scale. This could help identify challenges in the process and opportunities to make the permitting process more efficient. And with that, that's the end of the presentation. And I guess
We talked about third-party reviewers.
yes, sir.
When we talk about third-party reviewers for larger commercials and industrial projects, would that also be something you'd be looking for, possibly because of so much work, third party for engineering?
For the review of the plans?
Well, you have to have stamped engineer instead of having our county reviews the engineering.
Correct.
We sub that out to someone else, right? We don't have an in-house engineer.
That's correct.
So until we have one, we're subbing it out to someone else. Could the people that are doing the project pay for another engineer and to move the project so that one doesn't get overwhelmed if there's a lot of work out there?
That would, I mean, that's definitely a process we could think about. It would, in my opinion, it would probably fall, we'd have to do a statement of qualifications process and provide a list to applicants as far as engineering firms that the county would say meet the standards to review those plans. It is contractually through the MSA, the responsibility of Dow, so that would also take a change to that contract. If that's something the board wants to pursue, we can look into it.
I'm just looking at, that could possibly be a roadblock in the future if we have a lot of projects.
Dow has a 30-day review timeline, and contractually, they have 30 days to get comments back to us, once they receive the application. They're usually quicker than that, so currently it's not a huge issue of concern for staff, but if that's, like I said, if that's something the board wants to look at, pursue, we can definitely take a look at that. Really, the MOU with the fire district, I'd be lying to say we were currently working on that at the staff level and working with Central Lyon. Just like I said, to make that process a little bit more transparent. It's a give and a take. So yes, building permit applications would be allowed to submit to the county without approval. We just wouldn't issue the permit without fire approval. There is the instance if things change on the plans, the county would have to re-review the plans, which is my interpretation of why that policy change was made in the past. On the applicant side, it does save them a couple weeks as they're now in both queues concurrently. So there is a benefit there. We think it's something that staff can take on board and move forward pretty quick. We've had multiple conversations with Central Lyon and Elizabeth Mink over there, and they're on board with the MOU. We think that would be beneficial. The third party reviewer is a little interesting. I did put the 65% of the building fee. It's relative to the project valuation. For instance, the large data center projects, the valuation for those is in billions of dollars. So realistically, that building fee is in the millions of dollars. So you'd have to forfeit 65% of that. The way the contracts are usually written, we are talking to those companies to see if they're willing to put in a cap for projects. We've had successful conversations there, but typically they do want 65% of the plan check or building fee.
Commissioner Jacobson.
Well, from what I'm hearing then is if we could hire somebody else, we're not only going to pay for them and one or two of those jobs, we'd pay for another full-time employee for years.
Right, based on just the permit fees. It is quicker, easier to fill. It's not a position the county has to fill, or worry about turnover going to a third party. So that is a benefit. Always, if we can keep it in-house, that is also a benefit as far as communication there as well. So again, there's a little bit of give and take there as well. We can get the third party reviewer set up now, whereas we have to wait for those fees to potentially come in to have money to hire another individual.
So just thinking outside the box here. So let's say we have a backlog of some of these things and for requests. Is there a system where we can I'm probably going to screw this up, but where we can pay staff overtime to work and we keep, 65% of what you just said is a ton of money. So I don't know, and I haven't talked to any employees that might be interested, but if they had a chance to work overtime and get paid and cut down on this outside reviewer fees of 65% would probably save the county money. Some of our employees might make a little more money off of the top of those building fees, but it just seemed like we would keep a lot more money in the county as opposed to third partying this out.
Absolutely. And I use the data centers or hospitals or hotels. Those are just complex reviews. So
right.
I don't know, Ray could speak to it a little bit as far as the time it potentially take to look through one of the studies plans, but it is.
Oh, I can only imagine what we've had the last meeting alone.
Yeah.
It was insane the amount of time that had to have gone into all of that for county staff. And, I don't know how you got it all done, but.
That is an option for sure. We don't currently have any overtime in our budget this fiscal year.
Well, and I don't know that does it take a budget if we're getting these fees? I don't know how that looks. That would be probably a Josh Foley or you guys question. But it just seemed like there's some things we could do that would benefit the county, speed up the process, and keep that all in-house.
Commissioner Hockaday.
Well, and I know that with the code adoption on 1 January that we got dumped on 31 December. Have we got over that?
We did, yeah. So we looked at it this morning. Our oldest permit is from February 20th, so today's 16th, so a little less than a month.
So we're caught up. What's the basic time for wait now?
We usually, if the oldest permit's 4 weeks old, we usually, when people ask, we give them the week before and a week after, so we would say 3 to 5 weeks.
Okay.
And the hard part about giving people timelines is, they are subjective based on the complexity of the projects in the queue. That's why the third party would help us. It would pull those out of it. The general public, general contractors, in the communities wouldn't be, have the burden of those projects in the system taking up staff. I know we can project.
So, oh,
I'm sorry.
Commissioner Castanelli.
Thank you. Yeah, just a couple comments. I like the idea of the MOU. I think we should probably put some sort of a time frame in there for the fire districts, because I hear a lot of the permits kind of get stalled on their end as well, on their approval process, but I like the idea that it could be working concurrently. On the third party review, I think once we start getting into some of these projects that we know likely pending, I don't see another way around it, but the 65% fee is, not great. So, I mean, I'm looking at it like staff does the larger projects and give the third party reviewer the average projects that they can then, because it speeds the whole project process up. Having two, plan reviewers going on at the same time. And the third party reviewer, that's a pass through.
So that,
correct?
no, so they want, we collect the building fee and then we'd have to pay them 65% of that. We have been
Yeah.
talking with them. They are willing to put a cap on projects between anywhere from $100,000 to $200,000 for those fees, because it is a lot of money to be just handing over. So they're willing to produce a cap, and sign a contract with that in it. It's just whether the board wants to move forward with that or not, and what type of projects we want to utilize that service for.
So that wouldn't necessarily be a pass through to the applicant then on those fees too, then.
Right.
Okay, so if that's the case, I agree with Commissioner Jacobson. I mean, we're at the point where we're at a salary for an additional plan checker. It makes more sense for me to try to do something like that. But I don't know how in the short term we're going to get by without utilizing them.
So there's a way that you can put that into AI where they read the plans.
We do, and we're also looking at, our software, it is a little bit of a bottleneck, staff can work with it. We've had demos some different softwares moving forward. They do have an AI plan check to where when an applicant is going through the process, it'll run through the plans preliminary. I don't know how accurate it is. That wasn't specified in the demo, but it would, and then it would highlight areas of missing information or corrections. You can upload county code or specific building codes where you have consistent issues with, and it can highlight those changes before the applicant clicks submit, and then that application moves forward. There is some useful tools as well as far as the plan review side of things, where when we get revisions, the system will compare the plans and highlight the revisions. So staff's time looking through the pages to see revisions that may not be clouded or redlined or clearly highlighted. That is a benefit. Currently, we're trying to figure out, can our current software provide that service to us? And if not, I think we'd be looking to move forward with another software. The biggest part of that and the challenge of that is finding the right one. There's a Douglas County just went from Acela, which we would treat as the gold standard for software, to Oracle, and they were allowed to put the fire districts and the entire county on the one platform, which is a unique scenario. And we have been talking with them to see how that works and what it took for the fire districts to be comfortable being in a platform where everyone is a part of. So we are looking at software improvements there. Like I said, staff's job is to work with what we have, and we can do that. It does everything we need. But are there advantages to looking elsewhere? I would say probably.
Would that software alleviate the need for a third party reviewer?
I don't think so.
Okay.
Yeah.
Well, I do want to hear from the contractors real quick, and you can take this off the screen so we can see participants. Anyone in the industry. So I'm opening it up to public comment. Do I have any public comment?
Yeah, Mark Jones, I was talking to contractors yesterday. Some of them can't be here, so But some of their concerns is that the goalpost keeps getting moved in a process, like I have a individual that's had a house building over here in on Artist View, and they told him first off, he was in a floodplain. Well, he's like 40, 50 feet up where the construction is. And they told him go do a topo, so he did, and he came back with it, and he said, well, we don't need that now, we've changed our mind. Well, that's the kind of thing that we've got to stop. We have to have simplified enough rules, so a guy goes in to build something, he knows what the rules are. The fire code, they told me that he had to include his house with the garage and the overhead of the front porch for the 5,000 square foot. So then he went and had his plans changed and separated his garage. And then the fire guy came back, said, no, we changed our minds, those don't count anymore. It's only where your living quarters are. Well, so now that's an expense that he went through that he shouldn't have had to go through to develop. That was just one of them. The AI thing, I think we're gonna have to get used to AI because it's here to stay. And there are programs out there that have been out there for quite a while for plan checking. Because when the developer builds, it's usually on a CAD program, so you can feed that CAD in. And that AI can absolutely, recognize what we put in there as our codes and stuff. And kick out a permit pretty quick. Or kick out a rejection or whatever. And you charge the applicant for the AI time. That computer's being running for their program. So it's a third party running the AI. We're not picking up an employee cost and stuff like that to do it. And we're gonna turn our permits out much quicker. And that's where, even in 24, whenever you still have a rub with people that we're not open for business. That we make it harder to do business than it needs to be. And I would hope that attitude is something we can work for changing, because we need people to come in here and want to do business. But they need to know what the rules are, don't change the rules, and do it in a timely fashion. That's what I'm here for contractors. Thank you.
Still under public comment?
Dustin Merton, contractor. I live in Smith Valley. I've been in Smith Valley since 2001. I've built houses in Smith Valley, Dayton, Silver Springs, everywhere in this valley, including Fernley. I was a superintendent or assistant superintendent before I was a contractor. This is a hard place to do business right now. It's not 3 to 4 weeks. They're quoting 10 weeks, 8 to 10 weeks. That's not going to always be that way, but it's been that way for more than 3 months. I haven't had a new job since January. I have not had a new job since January. We're not talking about current permits at all, but if you walk yourself through a process right now, you can pull it up on the internet. The way you intake a permit right now is through a portal. When you submit to the portal's going to outline all this documents that pre-fill out all of the information that you need to be able to proceed. There are certain drop-down bars on that program that are required, and then there are parts that are not required. If you fill out any of those things and don't fill out the required portion, it automatically stops you from proceeding. If you hit just the highlights, just the required items, it will let you keep proceeding all the way through to be able to submit your permit for a completed application. There is no gate beyond that process, so that if I just hit the minimum, when I don't give you any more information than you need because I'm looking for speed. Okay, so I hit all the minimum suggestions and I turn them in. Now I wait 10 weeks to get a correction letter saying you want additional information, which could have been caught at that gate because the software on the application software currently is terrible, right? Once you get a correction notice, you've waited 10 weeks to get a correction notice. You get a 4 or 5 item correction notice. Nothing on there is too terrible. It does sometimes highlight things that you haven't been asked for before. That adds additional time to that permit getting issued. 1 week, 2 weeks, and it almost always incorporates additional costs. When you drop down to the fire department, the Smith Valley Fire Department is not equipped to do fire inspections, in my opinion. They farm it out to a third party already in Carson City, who's a retired fire guy, who will do it at a fee. and then turn it back in, which will then get approved. That's been my experience of how the fire marshal works at Smith Valley. Sorry, fire inspections, not fire marshal. I recently heard that Dayton and the North County area is requiring fire inspections on things as small as 200 square feet. If that's true, that's a shed. And to set that guy sitting on top of a non-habitable structure that has to get fire approval seems insane to me. But is that my 3 minutes?
No.
Keep going. So I did bring suggestions to the county. I brought suggestions 3-4 months ago when I was getting told 8 to 10 week permits. I got face-to-face visits from the building official saying that one of my suggestions had been accepted. That has not been implemented at all. The average Lyon County building permits were coming out roughly 50 to 60 a month prior to this big blast. This is all available on the website. The website sucks, but you can find it if you look. Permitting 56 permits a month is roughly 2 a business day. That's not that many. Okay, that's the whole county except for Fernley. They're currently running in the last 3 months. Well, I guess if you include December, they're running in the high 70s to low 80s, which is a significant increase. That's a significant increase, and that's due mostly to this code change. However, if you break down those permits, most of them are re-roofs, water heater change outs, basic mechanical stuff that every other county around here is doing in 30 minutes. Most of those, Douglas County was mentioned with that Akella program. They've switched to that new one, which is called Opal. They actually closed their whole building department this week, so I couldn't get any information because they're transferring over to the new one. But I've built in Lyon County, Douglas County, Carson, Reno. Everybody around you is easier to operate than Lyon County as far as submittals go. When Ray first came on, he was pumping out permits in 2 to 3 weeks, which was so fast that we didn't have a financing place. I mean, he's capable. He's just overwhelmed because he's by himself, in my opinion, right? You've got one building official that works most of the county, and then you've got Gene working basically Dayton only. Gene's doing, when I was working in Douglas or Lyon County up in the north side, Gene was doing more than 20 inspections a day. It's not even possible if you divide that by an 8-hour day for him to have to cover Silver Springs all the way down to Mound House in an 8-hour day doing 20 inspections, not being able to break for lunch or anything else. And he's old and he's got high mileage and you've got no replacement plan for him. And if he goes down today, he has to do the inspections. Or you're taking Cleveland away from me, who's the new guy. And the new guy's still learning how to operate around here. I mean, he's off of his probationary period, but he's still learning how we all function. And he's currently having to run up to Silver Springs on a regular basis to offload some of Gene's. We need another guy. We don't necessarily need another plan checker. We need another building official. But if you could get a building official that was able to do plan checks, I know that Ray's got Cleveland helping with some of the smaller ones or the easier ones. Cleveland has a huge background in manufactured housing. So it's real easy to kind of lean on the expert and let him do some, but then he's not able to do inspections for us. If I was going to just beg for a plan that would work for me personally, Smith Valley needs its own day. If the way I suggested that this is my suggestion to the board. This first in, first out only works for the rich. It only works for the Dayton builders that are national builders that have thousands and thousands of dollars that can come submit 10, 15, 20 permits at a time. And they don't care when they get picked up because they can always close shop and go build somewhere else. But the little guys like us that make all of our money in Lyon County or Douglas County, we're in line behind those guys. And if I hit a sheep traffic in Smith Valley getting here, and the Lennar guy or the D.R. Horton guy gets here before me, I've got 20 permits in front of me that are all going to get inspected before I get mine. You've done 4 Smith Valley permits in the last month. You did 3 the month before, and you've done a total of 11 in this calendar year, and it's taken 10 weeks to get through those 11. 10 weeks, and half of those were re-roofs and things that should be over the counter. Douglas County does over the counter. 30 minutes is what they define it. My question to the board would be, how long do these take? What are I want measurables. What is supposed to be a re-roof inspection? What is supposed to be a residential inspection? What is give me time frames so I can measure, so that I can tell if we're performing or we're not performing. Because right now I'm getting in line for 10 weeks for a re-roof or a solar permit. Solar permit took 10 weeks. I'm not sure. I would ask the question on how long it takes to review that document once it hits the desk, but I'm going to guess a half an hour or 40 minutes. And for that to wait 10 weeks, that customer is out of, we're out real money. We're paying property taxes, or we're paying property tax, but we're paying construction loans for 3 months to get started on construction, because I can't submit the application for building permit until I own the land, because one of the gates is I've got to prove to you I own it. I can't submit it as the contractor on behalf of the customer unless I have them give me a copy of their driver's license and fill out a letter, turn it in. It's crazy. We don't have to do that anywhere else. Anyway.
Thank you.
You're welcome.
Did you sign in?
I don't know.
And if you don't mind stating your name for the record as well, please.
Dustin Erton.
Thank you.
Thank you, Dustin.
My name is Bart Hammock, owner of Hammock Brothers Construction here in Yarrington. Similar to Dustin, I've been here since started in some Valley early or the late 90s. Moved over here in 2005, and again, previously in the building department. I mean, to get a permit for new residential construction would be 4 to 5 weeks. Before the new building code adoption, I submitted for 2 plans, 2 permits. One was for my house, my personal house, little 2-bedroom, 1-bath addition with a little 2-car garage on it. Took me 3 months to get out of county. And then also probably in July, I submitted for a soft set mobile home foundation. Again, soft set. I'm not sure what they're looking at, but it took 3 months, both those 3 months to the day. And to me, that is just ridiculous. It's me, my son, and my son-in-law, and my other younger boys that run this little business. And for us to go to our clients and say, okay, we want to do this, but it's going to take 3 months. That's part of the process. I realize that it takes time to get these things done. Ray and his staff have been great to work with. When I call Ray and ask questions, he either gets back to me quickly or answers my question. Cleveland's been great. The ladies at the desk office have been good. It just, as Duffy said, they need help. If it's taking this long to get a permit, how are we supposed to stay in business and stay in this town to provide these services to the community? It sounds like Dustin does most of his work in Smith Valley and Gardnerville. We do all our work here in Yarrington. You don't have very many contractors here in town, and it's very difficult for us to provide the service to our customers when we can't get a permit. So that's just my 2 cents. Thank you.
Is there anybody else willing to speak? Wanting to speak? Okay, we'll bring it back to the board.
I think the discussion is, sorry, Gavin Hurst, Lyon County Community Development Director for the record. Their building department's pretty fragile, right? We talked about July, we talked about January, we had an instance, we had an inspector go down. Yes, Ray had to cover inspections because that's all we had. That did cut into plan review time. I go back to having community members, contractors reach out to staff because we were trying to figure out how to work that issue when our inspector went down in an unfortunate accident. And I will say Dustin Hurton came to us with an idea and we implemented it as far as giving him, I believe 2 days a week, if I remember right. Every Friday. And it's a balance, right? I mean, I appreciate, the concerns brought here today, but we have a job to treat everybody equitable too at the same time. As far as queue and stuff like that, I don't think Justin Urton's wrong, or Mr. Urton was wrong with any of his comments or anything like that. But I just want to go forth and say, yeah, our building department it's fragile, right? As far as personnel and the systems we have.
Mr. Castanelli?
Thank you. I got just a question on, as a contractor myself, I know a lot of permits that I've gone in for, since I'm not building homes, a lot of my stuff is actually over the counter. And I'm hearing today we're no longer able to do simple plumbing permits or roof permits or those types of things over the counter anymore, or is that?
It depends on the application. I would say if there's an opportunity for us to look at our current applications and make more of them over the counter, we're more than happy to do that. A re-roofing permit, for instance, is a building permit because there are inspections involved. But if we want to speed up any of those processes, we're more than happy to do so. It's just currently, yeah, it does require an application.
About like
sit in
a
the queue.
water heater, remove, replace.
So those are,
plumbing,
yeah, those are over the counter.
Those.
Yeah,
those
any
occur
replacement.
Same day over
Yeah.
the counter.
Yeah, but as soon as you start moving infrastructure utilities around, then that would require it.
Thanks.
Any other comments? So I'm looking at this and we need to work on software updates. We need to additional staff. AI. Need to steal from other counties of what they're doing. And I'm hearing that we need some measurables and kind of a list of what we can get done over the counter so people are aware of it.
Sure.
And we got to work on our IT application a little bit. Because if it's just that portal's just screwed up, that seems like an easy fix once you get into it, unless the software's terrible.
I would say I don't use the customer portal. I would encourage any of the contractors if they have input on that. I would say it's not as customer friendly as it should be. So they talk about the gatekeeper process. It doesn't look at what's inside the documents, right? We have people upload the same document in every required categories, and then you can kick your application forward too, right?
But if someone needs to correct their application and it's done on a portal,
right,
that should be like 10 seconds back to them.
Right now we do, the system does send an email out. We also send an email out to the applicant with the correction letter, because some cases, the software does not want to send it out or send it out in an efficient manner. So we like to hit both of those processes. That way we don't run into that issue. Like I said, the software does everything we need, but nothing we want. Just kind of the basis there. But it would be an opportunity for improvement.
To me, that should go back right away. I mean, if I don't want to sit at home and wait, and then I'll be calling you guys up going, where's my plans? Where's my, oh, you got to finish filling it out.
Yeah.
That communication needs to be quickly. And especially since that to me, it's an incomplete package.
Yeah, and sometimes it goes to the applicant, and sometimes the applicant's contractor, and then we get a phone call from the homeowner or the future homeowner. Where my plan's at, and they're not a part of the process because they're not.
Whoever submits it, that needs to get back to them, and they're responsible for fixing it.
Right.
I wanted to ask you a little bit about grading and site. When these big projects come in, we're able to give them their grading, their permit early.
We are able to, separate from the site improvement permit, they are allowed to start grading activities when it is for the development of a pad and exit, and that grading activity involves moving in excess of 50 cubic yards. They are allowed to pursue a mass grading permit for the site. Currently county staff internal to this building does not review the grading plans. Those get distributed to Dow. And then they provide us comments. We distribute those to the applicants, and then until we get Dow approval as the county engineer.
What I'm looking at is what's the revenue on those, since you're giving them out right away, and you're still working on the rest of the plan, right?
It's based on valuation.
Right. So some of these big things could increase to where we might fill in a little bit of this down the road.
Potentially.
Anybody else have? Commissioner Hendricks?
What would be ballpark the cost of a software upgrade?
I would say ballpark would be 200,000 and in excess. One, you have to pay for the setup fee, which is around 60 to 90,000 from our conversations, and then you have to pay for the software license for a year. The hard part about that too is, from our perspective, we'd like to get, our queue to a manageable situation for an extended period of time, before, like this, Mr. Hurt mentioned as well, it is a burden on staff to bring that, to fruition and to the public and make it an effective software for everyone to use. And I'm not saying it's not a good idea still, but I'd like to make sure that our queue is manageable, that we have everything. We fixed the over the counter stuff because that will keep permits flowing out for those smaller projects and adjusting kind of our applications there to resolve that. But that would be my recommendation is let's get the queue to a manageable point. We dealt with the last big conundrum that can impact the queue as far as the code update. And I don't see anything on the horizon, and knock on wood. But again, that goes back to that building permit being pretty fragile. That it just takes a little shake up there to extend that time pretty quickly.
Commissioner Casanelli?
Jacob didn't do, okay, I'll go real quick. I just, real quick, one of the complaints I'm hearing is if you're in the queue and 10 weeks goes by, you're up and a correction is found. What I'm hearing is they go back to the bottom of the queue. Is that correct? Or?
That's incorrect. Usually Ray gets them out in about 2 to 3 days once we've received revisions. Once I'm notified that revisions are in the queue. Yeah.
Okay. Thanks.
And I do want to note that Cleveland is helping out plan reviews, but that is his second job. His first priority is still inspections. I know that was brought up. But he is doing a lot of the smaller projects for us. Manufactured home combo permits, being an expert from the state, he does do those for us as well, but I just want to clarify.
Commissioner Jackson?
Thank you. I think I heard the word fragile a couple times, and I think this is more of a Board of County Commissioners issue than it is anything with planning or any of that. I think we've got to do something to provide more support, more resources, whatever it is. And I'm all for doing that. I would like to see maybe whatever it is that we need as a growing county, we need to grow the department. I mean, it just makes sense. But I would like to, whatever we need to try and get done by the time the budget stuff comes around, we need to know how we can support building and planning. Because the heat you guys are taking is heat we should probably be taking sitting up here, not you guys behind your desk trying to get all this stuff done. So whatever that may be, you guys are the experts, and I wholeheartedly want to support you guys. So whatever.
But we all know that we have budget constraints, and it's a chicken and the egg thing. We need growth in order to pay for the people we don't have yet. So yeah, well, hopefully we can get that balance. We just have to know where we're going to go. What's the best bang for our buck as we get revenues in, where we can start filling in some of those gaps and to get to the full end thing. But we can't just shotgun it, I guess, is what where can we get the best bang for our buck?
Absolutely. My recommendation would be to pursue a third-party contract. I mean, that's something we can get pretty quick and get going. We can expand the roles and responsibilities of that third-party reviewer to help us with the queue workload currently, and then we can micromanage that moving forward to really take a look at the bigger projects. And once those come in, I mean, we'll have revenues there. I don't know how those will work out across the entire general fund, but there will be large revenues coming into the county at some point for those large projects that will be the same capacity forward. And then maybe we look at hiring another position or two, or I mean, whatever the department needs at that time.
So what I'd like to do is make sure that you're building it to where we're not dependent on staff we get everything, software, all that, right? Because that's a one-time thing that we can purchase right away.
The software.
Yes, that
yes,
type of thing.
Yeah, yeah.
So I don't want to squander our one-time money that we're getting off these big permits and stuff. But being in the trades, I'm a contractor too, and it cycles. It goes like this. This is the way it works. So as that money comes in, we're going to expect a lot of growth fast to where it's going to be hard to handle, and then it's going to dip, and where we could be staff heavy, right?
Right, and that's why I think you need a balance of maybe the position and the third party contract there.
Yeah, so we got to come. You guys run the departments, but that's where I would work toward. So do we have any other comments?
And the last one on the board policy consideration, it's not really a policy consideration, but direction the staff to develop a feedback system. We recognize that a lot of complaints come to the board, but if they don't hit our ears, I mean, we're supposed to be reactive to those as well. And sometimes we can be reactive prior to them getting to the ears of the board. So if that's what that's there for, if it's useful, we can put something together. Whether it's I don't know if it needs to be an anonymous process or if it's just a box by the office where you can stick a handwritten letter in, that would be the intent there.
And I think that's important because what staff usually hears about their certain project or their certain thing, and that can kind of get screwed a little bit.
Right.
But if it's overall, how can this would help out the department, please start doing this happens in a different county, then you've got something not particular to a project,
right,
but to the county as a whole, which would help their project.
Right.
But when people come in and just talk about their project, sometimes it gets lost in the project.
Yeah, exactly. Yeah. And like I said, we're meant to be reactive and proactive at the same time, but if we can be reactive sometimes a lot quicker and help those contractors out and the general public.
So do we need a motion or you guys got it? Okay. So you know where to go. I want to thank the contractors that showed up so that we can start going on that, because sometimes we don't hear this and we want it to go fast too. That's how we get revenue for the county and everything. So thank you for coming in. Any other comment from the board? Okay, thank you.
Thank you.
That brings us to number 8, commissioner comments.
No, I'm just glad that staff could give us a presentation today. Thank you for your efforts. They get back to checking plans. My daughter's has been 10 weeks, so we'll see how they're coming to process here quickly. We hope.
Commissioner Casanelli.
Yeah, I want to thank staff also. I know it's really hard. Everybody gets beat up on now and then, but I know you guys are working really hard and we appreciate it.
Commissioner Hendricks.
Yeah, I want to thank staff and the contractors for coming in, and it sounds like we should really be thanking Ray.
Commissioner Jacobson.
I'll just echo what others have said here, but thank county staff for preparing for today's meeting, and of course to the public for their input. And we've as a county commissioner, I need to do better, and so that's hopefully where we're heading. Thank you.
Thank you, staff, and thank you for people that showed up on this agenda item. Brings us to public participation. No action will be taken on any item until it's properly agendized. It is anticipated that public participation will be held at this time, though it may be returned to at any time during the agenda. Citizens wishing to speak during public participation are asked to state their name for the record and will be limited to 3 minutes. The board will conduct public comment after discussion of each agenda item, but before the board takes any action. Any public participation? Any online? Closing public participation. It is 11:22 and we're adjourned.